Good day and welcome to another Paddocks Club tutorial. I'm going to deal with the Sectional Titles Amendment Act 2013. It's Act number 33 of 2013, published late in December 2013, and which you can download from the government website. That's www.gov.za under Documents and Acts. The Act includes a range of technical and conveyancing process amendments which by and large don't impact on scheme management issues. The first issue are three definition amendments in Section 1 of the Act. So architect and land surveyor, those terms are both updated to refer firstly to the Architectural Professions Act number 44 of 2000 and secondly to the Land Surveyor Act number 8 of 1997. In both cases, the definitions are now supplemented by a reference to Section 5.2 of the Act, and the effect of this is that the terms now only refer to architects or land surveyors who have obtained the SGO's qualification to prepare sectional plans. The definition of developer is also extended to include the developer's agent or successor in title for the purposes of all of Section 4 of the Act, which deals with the approval of schemes. Section 14 of the Act deals with the amendment and cancellation of sectional plans, and 14.8 has been amended by the inclusion of a reference to an application being made in the prescribed manner. Section 15b(5a) of the Act, which provides for the issuing of a certificate of registered sectional title in respect of a fraction of an undivided share of a section, never made a corresponding provision for an owner to make application for such a CRST. The amendment now inserts that provision and also deals with ancillary issues that the registrar must take account of, such as what supporting documents must be lodged and what endorsements must be made. There are amendments to Section 17 that deals with the registration of a transfer of a part of the common property. It has never dealt explicitly with the lodgement of consents by owners, bondholders, and holders of other real rights over sections, or the lodgement of their titles for endorsement, so it's been changed to make those provisions. It also provides for the cancellation of the registration of the section of an exclusive use area at the same time as a part of the common property is transferred. The amendment provides the basis for such a transaction. Section 17.5 of the Act provides for the title deeds of units, any registered real right over them, and the title deed to any registered exclusive use area to be lodged for cancellation on transfer of the whole of the land comprised in the common property. And the amendment makes provision for the consents of bondholders and right holders also to be lodged. Section 18 of the Act makes provision that the Deeds Registries Act of 1937 applies to the transfer of bonded sectional property and rights, but it didn't before cover bonded real rights of extension and of exclusive use, and so it's been changed to cover these also. Section 19 of the Act deals with the expropriation of common property or rights in it, as well as the cancellation of the registration of a section affected by such expropriation. The amendment takes this a little bit further and also covers the cancellation of the registration of just part of a section rather than the whole of a section. There's an amendment to Section 25(1) of the Act that provides for the extension of schemes, and that currently requires the authority of the unanimous resolution of the body corporate and bondholders. But as you know, unanimous resolutions don't involve bondholders, so it's now been changed to require just the consent of bondholders, those who held bonds at the time the resolution is taken. There are some amendments to Section 25 and 27. 25(4) of the Act provides that a right of extension reserved by the developer on opening of the register or one vested in a body corporate is deemed to be immovable property that can be mortgaged and transferred. But that deeming provision didn't apply to the type of extension right taken out by a developer after opening of the register and before the establishment of the body corporate. So the provision has been amended so that it does cover all types of extension right. The Act provides also for the issuing of more than one certificate of real right of extension and more than one certificate of real right of exclusive use right at the opening of the sectional title register. So finally, the Act, or Sections 25 and 27 of the Act, have been adjusted in a number of places to reflect that more than one of such certificates may be issued. Thank you for joining me in this Paddocks Club video tutorial, and if you have any questions, we can deal with them in the discussion forum.